Several civil society organizations have made submissions to Parliament for the removal of Public Protector Busisiwe Mkhwebane following recent adverse findings against her by the courts. To tell us more about this and how it can be done, we're joined by Skype by Council for the Advancement of the South African Constitution. That's KSAC's Executive Director, Lawson Naidoo. Lawson, a very good evening to you. And yes, we do understand that, for the longest time for yourself and other organizations, this has been a matter of some urgency. We know that what needs to be proved is the misconduct, incapacity or incompetence when it comes to the Public Protector. Do you believe you have enough to begin this process?
Certainly. Thank you very much, Rebecca. Yes, we certainly do. As you will be aware, a number of civil society organizations have previously individually written to the Speaker of the National Assembly suggesting that a quick and urgent process be commenced in Parliament in terms of Section 194 of the Constitution, which provides for the removal of the head of a Chapter 9 institution. The submission that we've made to the committee now, which includes groups such as Corruption Watch, Freedom Under Law, the Ahmed Kathrada Foundation, and others, deals with two aspects of this process. One is that we made a submission regarding the procedure to be followed, and we note that today the Justice Committee has decided to refer the process aspect of the issue to the Rules Committee of the National Assembly to determine appropriate rules to be followed in conducting an inquiry that would lead to a finding as to the fitness or otherwise of Advocate Mkhwebane. We believe that no such rule amendments are necessary, but we respect the fact that Parliament is taking a belt and braces approach to this and making sure that its processes will withstand any legal scrutiny that might come further down the line.
And for that reason, Lawson, who should be involved in this process?
Well, it's clearly the Parliament's Justice Committee that needs to lead the process, that in terms of the Constitution it needs to make a finding as to whether Advocate Mkhwebane is incompetent, has committed misconduct, or lacks the capacity to do the job. And once they've made a finding, they need to refer that matter to the National Assembly, and the House needs to take a resolution with a two-thirds majority should they decide to remove her from office.
Would this mechanism, you think, allow for the Public Protector for Busisiwe Mkhwebane to put up a bit of a fight for her job, to defend her herself?
Indeed, it must. Any process that Parliament follows must be one that meets the requirements of due process, of hearing the other side, of giving Advocate Mkhwebane an adequate opportunity to put her side of the story to Parliament so that they can then make up their minds based on an assessment of all of the information and evidence that is available.
Lawson, how long do you reckon it will take, or should it take, to come up with the rules to start this process, or for this process to get underway?
Well, we certainly hope that it will not take a long time. In fact, in the committee meeting this morning, a member of the Democratic Alliance, urged the chairperson of the committee to request the Speaker to fast-track this process of passing the relevant rules to allow the process to commence. We know that the DA Chief Whip has said that he has prepared a set of draft rules that he will present at an early stage. So we certainly hope that this is a process that can be done relatively speedily, but with due respect for getting it right and putting in place a robust set of rules that is not just going to be about this particular process of removing this particular Public Protector, but one that will be long-standing and cover any future scenarios where a head of a Chapter 9 institution needs to undergo such a disciplinary process.
And Lawson, we know that a lot of this comes out of the controversial reports that Busisiwe Mkhwebane has worked on, some of her findings as well, a lot of them being highly criticized by the courts as well. So what would happen if this process went ahead and, you get your wish and that she is removed from office? What happens to those reports, those findings? Do they become invalid, null and void again? Do we start those processes all over again?
Well, the reports that have been challenged in the courts and those that have been set aside, the CX Absa Bancorp report has been set aside, the Frida Dairy Farm report has been set aside by the courts. So, those reports that have been taken on review and have been set aside will obviously remain in that state. Other reports that have not been challenged will remain valid, regardless of the removal of the public protector, because it's not linked directly to all of the work that she has done, and that reports that are unchallenged will need to be implemented. The remedial action will need to be implemented. So, it's not throwing out every bit of work that the public protector has done, but merely those reports that have been successfully reviewed.
And very quickly for us, Lawson, of course, it's not just Busisiwe Mkhwebane who works on these things alone. Will you be looking at those who work under her as well, those who might have contributed to these investigations and reports, also for whether it's misconduct, incapacity or incompetence?
Well, that may be something that comes out of this process of this inquiry. But ultimately, the public protector, Advocate Mkhwebane, is the accounting person in that office. She is responsible. She signs off on the reports that have been successfully reviewed and which have attracted judicial criticism. So it's with her that the buck stops for now.
All right, thanks very much.